over with the roll call, because we didn't get the
You
first
get that
part of
part.
that on
Roger
the
that.
recording, so I'll
Go ahead,
apologize.
ma'am.
Yeah, we haven't done roll
That's
call.
where we are.
I'll call to order.
You still hear me, Dr. Callis?
Yes, I'm still here, sir.
I think you broke the system, just for the record.
Thank you, sir. I appreciate that. Always blame me. It's fine.
That's a good source. Is there a temperature down?
Yes.
We requested it to be turned down, for the AC to turn on.
Doesn't mean it was done.
A little bit right here.
It's not gonna cool off fast enough.
He's savvy.
Are you doing emergency disaster response? Because I'm not arguing anymore, that's all he's got there.
So when's this?
You should just carry it.
When did what?
Is the scan box.
Okay.
Is it in the calendar?
Walk up there. You.
Yes, okay, we're recording. Can we start over, please?
Yes, ma'am. Yes, ma'am.
Thank you.
You ready? All right, we'll call meeting back to order again, 8:42. We've done the invocation, so I think we're covered. I can go be on YouTube, right? That's a good thing. All right, when you roll,
Yes, sir. Chairman Rick Figueroa,
here.
Vice Chair Tom Butler, Dr. Ray Callis,
Virtually here, ma'am.
Dr. Gary Wesson,
Here.
Commissioner Collier, Commissioner Nora Castaneda.
Here.
All present except for Dr. Collier and Vice Chair Butler. Thank you.
Mr.
Well, quorum
Commissioner,
present?
Chairman,
Yes.
I
we have a
recommend that
quorum.
we accept the excused absences of those two commissioners that are not present.
Is there a second?
A second.
All in favor, say aye.
Aye.
Opposed? All right, motion carries. Okay, for those in the audience, must remain quiet. There are microphones in the ceiling, so they're very sensitive and they pick up a whisper. A few quick reminders, please make sure your camera is turned on the entire time. Dr. Calla, mute your microphone when you're not speaking. Please raise your hand. If I don't see it, make sure, Doc, you wave or something, because I'm looking straight ahead. If you'd like to be recognized to speak, and then we'll make sure to say your name for the record. We're gonna go to item C, right? A public comment.
Yes, sir.
All right. We're accepting public comments in writing, in person, and video conference for call for those who submitted requests in advance to speak in the commission. We received written comments as well. They've been provided to you. We'll bring the first commenter of the meeting. That person will have 3 minutes to speak. Make sure let me know, just raise your hand, we can 3 minutes. There'll be a brief pause while bringing the next commenter into the meeting, and then the person will have 3 minutes to speak, and so on. So,
Thank you. Chairman, we have Mr. Michael Moats up first as the public commenter.
okay.
Mr. Moats?
Morning.
Mr. Post, can you hear me?
Yes, can you hear me?
Yes, sir. Give me a second here. This is Chairman Figueroa. Thank you for being here. Please say your name and who you represent. You'll have 3 minutes. Please understand the commissioners are not allowed to ask questions or engage in discussion with you about anything that's not specific on the agenda. Please also understand the commissioners cannot hear any information about any pending complaint or an enforcement case, because it may ultimately be a decision maker in the case. Do you understand, Mr. Moats?
I do.
Perfect. Okay, you've got 3 minutes, sir. Go ahead.
So I'm here this morning to oppose the renomination of any individual on the Behavior Analysis Advisory Committee. By statute, the committee has the ability to approve alternative certification boards other than the one that TDLR currently accepts, so you can approve more than one, and over a year and a half now has refused to do so. TDLR has been aware that this request has been asked for since September of 2020. The advisory board has been aware of it and has taken no action. And just to be frank, the certification board that is currently approved by TDLR currently certifies individuals who are engaged in the practice of shocking minor children using electricity. They attempt to modify their behavior by shocking them. Individuals have ended up in the hospital with first-degree burns as a result of being shocked, and it is an unethical, inhumane practice, and we treat prisoners at Guantanamo Bay better than we treat individuals who are students with autism. So I've got about a minute and a half left. I just want to show you what this looks like. So here's the video.
And on his head, screaming for help. The Judge Rotenberg Center calls it treatment. I was shocked when they were 16, 17. As McCollin's attorney just described, the
Literally holding children down and tying them down face down and shocking them. And this is the board that approves the behavior analysis certification board that approves the people who do this. Is the only board that is approved by TDLR. And for a year and a half, y'all have taken no action on any alternatives. So that's what I have to say. I wholeheartedly think that we need a new team because that kind of practice is inhumane and acceptable.
Thank you, Mr. Moats. I appreciate your comments. I can assure you we'll look into what you're talking about personally. And I don't understand exactly what the video had to say, but we'll appreciate your comments and we're going to move on.
Thank you.
All right, up next we have Nicole Kosich.
What's your last name?
Kosich.
Kosich. Ms. Kosich, can you hear me?
Hello?
Ms. Kosich, can you hear me?
Yes, I can.
Okay, this is Chairman Figueroa. I'm going to read you some instructions and then we're going to go from there, okay?
Okay.
Okay, so thank you for being here. Please say your name and who you represent. You have 3 minutes. Please understand the commissioners are not allowed to ask questions or engage in discussion with you about anything that's not specifically on the agenda. Please also understand that commissioners cannot hear any information about a pending complaint or enforcement case because we may ultimately be a decision maker in that case. Do you understand, Ms. Cautious?
Yes, sir.
Okay, you got 3 minutes. Go ahead and go.
Okay. Hello, I'm Nicole Kosich. I represent myself and students that are interested in becoming massage therapists and basically the general public and Kosich International Institute. And I'm here to request that under Subtitle H, Profession Related to Certain Types of Therapy, Chapter 455, Massage Therapy, Chapter A, General Provisions be honored and addressed. Number 9, Massage Therapy Instructor. As you can see here, I have what I got when I went to school, the occupational code. And it says here, the sole purpose introduction is to compile the relevant law, arrange it in a logical fashion, and rewrite it without altering its meaning or legal effect. I'm here to state that the meaning and legal effect seems to have been misinterpreted and get that addressed with the commission. I am more than willing to come in for work groups and volunteer my time or strategic planning, whatever needs done. But a massage therapy instructor, the clarification is easily here on page 1 of the rules that were instituted and under the law. Under the law, you had instructor, and it means a person who instructs a student in any section of the course of instruction required for registration as a massage therapist. A massage school means an entity, teaches a minimum course of instruction required for registration as a massage therapist, and has at least 2 instructors. Instructors, as they were taught in school, I'm sorry, it's right here, was so that if a school needed to hire additional personnel to cover certain subject matter, and have substitute teachers. But a massage therapy instructor, a licensed one, means a registered massage therapist who provides to one or more students instruction in the basic course of massage. As you go on here, you will see the powers and duties of the board is the general rulemaking. And rulemaking for massage schools, massage therapists. Nowhere does it say that they should alter the massage therapy instructor. It goes further on to say everywhere in here throughout this student internship program be conducted on the school grounds or in a clinic or classroom setting provided by the massage or massage therapy instructor. A student must complete the hours at a massage school or a massage therapy instructor. It is throughout the entire document. And whenever somebody recommended on a board to TDLR that it was repetitive and it should be revoked, they took out section 455.055 rules regarding massage therapy instructors. They also took out the financial ability to not be burdened with additional licensing when they did so. And they made it so that school licenses would be.
Can you hear me
Yes,
for a
sir.
second? Okay, your 3 minutes is up. Your 3 minutes is up. I appreciate it. But I tell you what,
Okay.
I understand what you're trying to say. And Mike, can we, or I guess Mike, Christine, can we have somebody from our staff follow up with her on this, making sure that we've addressed this, especially in the advisory committee? I know that I hear what you're saying, and we'll follow up with you. Okay?
Okay, do I need to send an email? Oh, I'm sorry, I'm not supposed to ask questions.
That's fine. We will have, I promise you, as chairman, we'll have somebody follow up with you personally through email, okay?
Thank you so much.
You're very welcome. You're very welcome. Next.
Next commenter, we have Attorney Dag Fabus.
Fabus.
Yes, Faubus. I believe I pronounced it right,
Okay.
Mr. Fabus.
Mr. Fabus, can you hear me?
I can.
Okay, I'm gonna read you some instructions. I'm gonna read you some instructions if you don't mind, and then we can go from there, okay?
Excellent.
Thank you for being here. Please say your name and who you represent. You have 3 minutes. Please understand the commissioners are not allowed to ask questions or engage in a discussion with you about anything that's not specifically on the agenda. Please also understand the commission cannot hear information about a pending complaint or enforcement because we may be ultimately the decision maker. Do you understand, Mr. Fabus?
I do.
Okay, perfect. You have 3 minutes. Go ahead and go, sir.
Thank you. My name is Dax Fabus, and I'm here on behalf of Texas homeowners. I've been compelled to request to speak here because over the last several months, I've seen or understand certain attorneys for home builders have talked to you guys about what they believe to be, the need to limit air testing of wall samples. And having been on the front lines of the many, many, many home defect claims that we've seen over the last 10 years here in Texas, I can tell you that would be a grave mistake to do that. My understanding is that home builders have renewed their efforts both at the legislature as well as here in order to, prevent or remove the discretion from mold assessors for utilizing air sampling of wall cavities to determine the extent of mold in a home. I've even heard of allegations that $2,000 remediations turned into $200,000 remediations. Well, I've yet to see how mold can be created by a mold assessment technique. If this is done, of course, the reason why this is happening is because home builders have been the subject of millions of dollars in arbitration awards over the last several years for these very issues. One of the more important things that is considered in these arbitrations is the extent to which there is hidden mold in these homes. And of course, taking air samples of wall cavities is a hugely important tool to determine that extent. And, we've had ex-Harris County judges who were known to be conservative Republican judges while they were on the bench, who have issued these awards. They have literally judged thousands of trials and judged the credibility of thousands of experts and have determined that the experts who make a concerted effort to find the hidden mold in these homes, including taking air samples from wall cavities, are more credible than the home builder experts who, while recognizing the importance to find hidden mold, choose to stick their heads in the sand in terms of finding it. So what they're trying to do is limit their liability, limit the ability for homeowners to prove their cases, including increasing the cost of doing these inspections. If we are required to do invasive testing, that will drastically increase the cost of the investigations. And so I submit that the emphasis should be instead on finding hidden mold instead of limiting the ability to do it. Thank you.
Mr. Fabus, thank you so much. Your insight and comments, this is a paramount issue, I know, with a few commissioners here on the commission, so thank you for your comments, okay?
Of course.
Absolutely. Okay. All right.
Thank you very much, Mr. Chairman. Next up, we have Ernest Freeman. Attorney Ernest Freeman, are you on the line?
Yes,
Mr. Freeman, can you hear me?
I can hear you, yes.
I'm going to read you some instructions, and then I'm going to give you 3 minutes, okay?
Okay.
Thank you for being here. Please say your name and who you represent. You'll have 3 minutes. Please understand the commission are allowed to ask questions or engage in a discussion with you about anything that's not specific on our agenda. Please also understand the commissioners cannot hear any information about a pending complaint or enforcement case because we may ultimately be the decision maker in the case. Do you understand, Mr. Freeman?
Yes.
Perfect. You've got 3 minutes. Go ahead and go.
Thank you. My name is Ernest Freeman. I'm a licensed Texas attorney. A good part of my practice is engaged in representing homeowners in the Houston area for various types of construction defects to include mold problems. And it's my understanding that there's been individuals that have come before this committee in recent months voicing their request to essentially have this committee do away with Section A of 78.100 of the TMARR, the Mold Assessment and Remediation Rules. And based on my knowledge of the background, the individuals that are pushing this are primarily the attorneys and as well as builders who are represented by these attorneys. And in my opinion, I think that would be a really bad turn of events in terms of what the purpose of this regulation is supposed to do. The mold assessment consultants, as part of their job, are mandated by their own guidelines and protocols, as well as the EPA and the AIHA, to find the source and extent of mold, to include hidden mold. Oftentimes when families come to me during these cases, they're at their wits' end because they're getting sick. They know they have a problem, and as it turns out, in most instances, the builder didn't follow simple building codes that would have prevented these sort of problems. So I think as it currently stands, the rule is subsection A specifically is uniquely tailored in a good way to allow the mold assessment professional to determine the extent of mold as they're supposed to do. If you removed that section or changed this regulation, what it would end up doing is tying the hands behind the back of the homeowners specifically to develop their cases. And the background of this, of course, is the fact that the builders don't want a level playing field. And so these cases are expensive, they're time consuming. By the time a family comes to someone like me, they can't oftentimes live in their house. And this would be squarely at odds, I would add, and final by saying this, if this regulatory change were to occur, it would be squarely at odds with the Texas Residential Construction Liability Act, which is Chapter 27 of the Texas Property Code. That requires a homeowner to present the builder with a detailed outline of exactly what's wrong with their home, exactly what the required protocols are to fix the home, and how much it costs. And so if you told a mold assessment consultant that they couldn't go and test at the walls, for instance, to find hidden mold, you would limit their ability to do that. And that would be a gross miscarriage of justice, in my opinion, and is not what the purpose of this regulation is for.
All All right, Mr. Freeman, thank you for your comments. I know where we are in the middle of this right now, adopting this thing, so I appreciate your 2 cents on this.
You bet. Thank you.
All right.
Up next, we have Michael Oda.
Mr. Oda, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, sir. I'm going to read something and then we'll start there, okay? Thank you for being here. Please say your name and who you represent. You have 3 minutes. Please understand the commissioners are not allowed to ask questions or engage in discussion with you about anything that is not specific on our agenda. Please also understand the commissioners cannot hear any information about a pending complaint or enforcement case because we may ultimately be a decision maker. You understand, Mr. Oda?
Yes, sir.
Okay, you got 3 minutes. Go ahead.
Thank you. My name is Michael Ota. I'm a BCBA, and I am also a board member of the Autism Society of Texas. I would like to thank the chairman and the commissioners for this time to speak. I'm here specifically to add my testimony about the rules O for implementing the provisions of telehealth for ABA from SB 40 from the last legislative session. I would implore the commissioners to allow for all services of ABA to be included in telehealth. That includes one-on-one direct intervention, the training of parents, and for groups. This is very much needed to provide stability and equity in our field. As right now, for instance, certain insurances allow for different types of services, and it just depends on the luck of the draw of which insurance policy you're on. The reasons for telehealth are that it provides much greater access, especially with clients that I have that live in rural areas. It definitely encouraged participation in the therapy, as I have lots of clients that come on that need to kind of edge into ABA therapy, and it's important that we're allowed to provide that access through telehealth instead of having them drive into the office for a 15-minute visit. And like I said before, it also provides the equity when everybody is playing by the same rules. And most importantly, and I know the board does not have any jurisdiction over insurance, but I do know that with the insurance companies that I deal with, that they are specifically pointing to the decisions that will be made today in order to allow for continuing telehealth. Right now, it's a continual basis of allowing for a couple more months, and it's leaving our clients, our parents, and our business kind of up in the air until we know if we can continue telehealth, which is right now serving many of them in the best way that they for their needs. So again, I appreciate the time, and thank you.
Thank you, sir. We'll make sure and have our 2 doctors on our commission take a look at this. Thank you.
All right, up next we have Linda Lawver.
Ms. Lauber, can you hear me?
I can.
Okay, I'm gonna read you some instructions and we'll go from there, okay?
Okay.
Thank you for being here. Please say your name and who you represent. You'll have 3 minutes. Please understand the commission are allowed to engage or ask questions and discussions about anything not on the agenda. Also, please understand that we cannot hear anything about a pending case or enforcement case because we may ultimately be a decision maker, okay?
Yes.
You've got 3 minutes. Go ahead.
Okay, I'm Linda Lawver. I'm here on behalf of homeowners and business owners. The Texas mold rules were put into effect 17 years ago, and they work. They were written by a group of people, including but not limited to industrial hygienists, PhDs, and engineers. They knew what they were doing, and they did a good job. There have been persons in the last meeting that spoke about changing the mold regulations, which the specific thing they want to change is the scope as written in 78.100 of the mold regulations. These general work practices are minimum requirements and do not constitute complete or sufficient specifications for mold assessment. More detailed requirements developed by an assessment consultant for a mold assessment or for particular mold remediation projects shall take precedence over the provisions of this section. These people want to limit the mold assessment consultant's ability to determine if there is mold inside walls. The EPA and the AIHA both say that you should find mold if it's in the wall, determine if you have hidden mold, and remediate it. If this provision is taken out, we won't be able to do that. We can't cut holes in the walls of people's homes. We can't cut holes in commercial buildings and government buildings that are occupied. So I ask that you please remember that. Thank you.
Thank you so much for your comments. We appreciate that. Thank you.
And Mr. Chairman, that was the last one.
Last one?
Yes, sir.
Okay, thank you. All right, that was great. We're gonna move on to item, the executive session was item D. We'll go into executive session to consult with an attorney under sections 551.0711 and 551.0712 Government Code. The time is 9:07. After the executive session, we'll take a break and come back here and let's give ourselves, Mr. Bowman, 30 minutes.
That should be plenty of time, sir.
All right, so we'll do 9:37. We'll come back here. It's 9:07 now, and pick up with any action items on executive sessions, and then begin the contested cases. All right, Dr. Callis, you have we lost him, didn't we? I'm sure he knows how to switch over to this.
Yes.
Okay. All right. 9:45. We're back from executive session, and we're back into open session. And there are no action needed on the executive session items. So we're going to go to item F. If somebody can make a motion.
I'll make a motion.
So move.
Second?
Second.
All in favor, say aye.
Aye.
All right, we got electronic signatures. And then item G, discussion of possible action on assignment of commissioner liaison boards. Mr. Bowman, can I bring this up?
Absolutely, sir.
Okay. All right, commissioners, I have got a list, and Ray, you're going to get this list of all our advisory boards. I want to kind of recalibrate. If there's a particular board you want to be on, or you just let us know. Carnegie, can you make sure everybody gets a copy of this?
Yes, sir.
I'm going to give you a couple weeks, and then if not, I'm going to assign you one. So,
Yes, sir.
And make sure that everybody has one. As you well know, as you through public comments, these things are becoming more and more prevalent, especially in our transition of more licensees. So make sure we want to make sure everybody gets their say, and this is where the work's done. So we'll get that situated. Item H is the strap plan. Emmett?
Yes, sir. Mr. Chairman, Commissioners, good morning. My name is Emmett Macon, Chief of Staff. For item H, we are requesting appointment of a Commission Strategic Planning Work Group. Strategic planning kicked off for this 2022 cycle at the end of February. We have various teams already working on many parts of the strategic plan. The work group will offer direction and guidance to staff as we move forward to bring your product by your May meeting, and the final plan is due on June 1st to the state. So we're requesting appointment of the work group, and we will continue to consult and collaborate with the commissioners on that group.
Okay. Commissioners, if there's somebody who wants to be on this work group, let me know, and I will put you on this work group. This is you might want. This is a pivotal work group. This basically does a lot of future planning for how we execute our strategy and within the in-house, and the work within the legislature as well. So they read this well. So if you want a piece of this, let me know. Okay. If not, I'm going to appoint. So there you go. All right. Anything else, Emmett?
No, sir. That's it.
All right. Perfect. All right. And then do we need a motion on either one of these, Brad? On H or G?
And no, sir, not a formal motion. If there's any action you want to take, that this could be a time to do that, but it's not required.
I'm going to give the commissioners until May to make sure that we have their ask on this. Yes, ma'am. Did you have a question? Okay, okay.
Chairman, Mike Harrison, Executive Director. The liaisons, I believe, can wait until the May meeting. We would request that probably within the week, we have a work group already assigned for the strategic plan so that we can get that one done and get the input from the commissioners on that subgroup so that we can proceed to make sure we get in the strat plan drafted and finalized to the point that we can bring to the commission on the May 24th meeting to get approved by the commission.
All right.
So we would want probably.
You want a motion on that? But I'll appoint, are y'all good with me appointing, you just meant to move it to for the chair to be able to appoint this? Is there a problem with that?
I'll make a motion for that.
Okay, second?
I'll
Second.
All in favor?
Aye.
All right, I'll have it to you by end of week.
Sounds great. Thank you, sir. Thank you,
Absolutely, that's
Commissioner.
right. If not, you're free to hound me. All right, the minutes. Commissioners, you had a chance to look at the minutes. Any motions?
Yes, sir. Make a motion to approve the minutes from January 25th, 2022.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries, okay. All right, we're gonna move on to contested cases. Carnicia, are we ready for this?
Yes, sir.
Okay. All right, here we go. If anyone has indicated they are hearing today and for the case, staff will provide them with information on how to connect this meeting. We'll bring them into the meeting when we announce the case, okay? First case. Item J, 1. Mr. Martinez and Jessica. Good to see you, Jessica.
Good morning. Good to see you, Chairman.
Do we have Mr. Martinez?
We're currently checking.
Okay.
So every meeting we can do except for Zoom, except when we should attend these.
Correct. Correct.
Mr. Chairman, Mr. Martinez is not available.
Okay. Is there a pause for this, or do we, is he just not gonna be here?
I don't believe he seems to be online.
Okay, all right. Ms. Hurtado, you got the floor.
Thank you. Good morning, Commissioners. My name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. The ALJ recommends that you deny Roberto Martinez Sid's apprentice electrician renewal application and revoke his license. In 2016, respondent was convicted of criminal trespass and misdemeanor and was later granted an apprentice electrician license that same year. The respondent continued to renew his license until his latest renewal in March 2021. In November 2020, Mr. Martinez Sid pled guilty to robbery, a felony offense. He was placed on deferred adjudication community supervision for 5 years. Mr. Martinez Sid and 2 other individuals were driving in a vehicle that collided with the victim's pickup truck. Respondent and the other individuals exited the vehicle, pulled the victim from his truck, and began punching and kicking him. The victim was struck with a tire iron, and respondent stole the victim's truck and fled the scene. On March 2nd, 2021, respondent submitted his renewal application and answered no to the criminal history question. Respondent was not truthful in his answer because he failed to disclose that he was on community supervision for robbery. Respondent also failed to provide information to the department regarding his robbery offense and failed to offer an explanation for why he answered no on the criminal history question. He did not provide to the department any of the necessary information needed to determine whether a restricted license would be appropriate for the respondent. Now, while Mr. Martinez Sid testified at the hearing that he has completed an outpatient program as well as currently attending aftercare sessions, he offered no evidence to verify these rehabilitative efforts. He testified that he previously worked on commercial or new construction job sites through his union, but he did not offer any testimony regarding whether another licensed union member would be willing to supervise him if he was granted a restricted license. The ALJ found that the respondent's robbery offense to be of great concern. Mr. Martinez Sid was 22 years old when he participated in the assault of the victim and theft of his property. And at the hearing, he offered no explanation for his conduct. The ALJ notes that the offense occurred less than 3 years ago, and the respondent will remain on supervision until 2025. Thus, the ALJ concludes not enough time has passed for respondent to establish a record of good conduct. And while the ALJ recognizes that Mr. Martinez Sid has participated in some type of rehabilitative efforts, It is unclear what specific issues those efforts are attempting to address. Finally, respondent did not provide any other evidence to support his fitness for licensure. Thus, the ALJ concludes the respondent's deferred adjudication may be treated as a conviction for licensing purposes. The ALJ also concludes that a restricted license is not appropriate for respondent because he has not yet discharged his community supervision and because his criminal history reflects an escalation in the seriousness of the offenses. The ALJ believes that the evidence is not sufficient to show that supervision would be adequate given the violent nature of Mr. Martinez-Sid's robbery offense. Additionally, the ALJ concludes that respondent's failure to provide requested information to the department also weighs against his suitability for a restricted license. Finally, the ALJ concludes respondent falsified his renewal application when he answered no to the criminal history question. The ALJ was not persuaded by Mr. Martinez-Sid's testimony that he thought the question only asked about convictions. The ALJ points out that the respondent has renewed his license on 3 prior occasions prior to his most recent application, and thus he would have been familiar with the wording of the question. The ALJ also notes respondent was placed on deferred adjudication only 4 months prior to his submitting the renewal application, and therefore the ALJ concludes the department may revoke respondent's license based on his false answer. The ALJ recommends you deny respondent's renewal application and revoke his apprentice electrician license. I ask you to adopt the PFD as written, and I am available to answer your questions. Thank you.
Thank you, Mr. Tardo. Any questions from Mr. Tardo?
Oh, one thing, so the way it was stated, was there any leeway there to where he could misinterpret it when they asked him about criminal conviction?
That was his testimony at the hearing, that he misunderstood the question.
And the way we stated?
The way we say it, the way it's stated on the form, it asks about convictions, and then it asks or deferred adjudication.
So there should be no.
No, I don't think there should be any confusion.
Okay.
Mr. Chairman?
Yes, sir.
May I, it's Brad Bowman, if I could add one thing just to note. Staff made numerous attempts to contact the respondent, and he has not gotten back with us. So yesterday, I think there were calls, emails that went to him. He did not attend the practice session or the virtual, to make sure their connection works and all of that yesterday. And we just tried to reach him again this morning, and we're unable to. So just wanted to note that.
Thank you, Mr. Bowman. Any other questions? Okay, I'll entertain a motion.
Make a motion to accept the PFD as written.
Second. Second. All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you, Ms. Cotto.
Thank you, Commissioners.
All right, we're on case number 2, Hermes. Mr. Thielen, good to see you, sir.
Good to see you.
Are we, Carnicia?
Yes, and we do have Mr. Hermes and his attorney, Jonathan Bruce.
Mr. Bruce. Mr. Bruce, can you hear me? I don't think you can hear me.
He's on mute. So.
Mr. Bruce. Mr. Hermes is not there either. I don't think they can hear us.
Mr. Chairman, if you'd like, we can probably move on to the rules and we can try to reach out to them, see if we can get them online.
Roger that. Okay, yeah. We're going to stall that one for till we get back.
And he just.
Mr. Hermes. Mr. Hermes, can you hear us? Mr. Hermes?
Is he on mute?
Mr. Bruce? All right, we know Mr. Bruce. We can give a little leeway. Once you will come back, we'll do one rule. Mr. Thielen, give us a few minutes if you don't mind. Gladney, good to see you, sir. Good to see you. We're going to give you K. Item K, rules.
Good morning, Mr. Chairman and Commissioners. My name is Mark Gladney, Assistant General Counsel for TDLR, and I'm here to present for adoption by the Commission the rule package implementing House Bill 139, passed in the last legislative session.
I'm at a hearing in the Texas Department of Licensing and Regulation.
Hang on. Mr. Bruce, we're going to come back to you. Can you hear me?
Yes, I can.
Can you put yourself on mute for a second and we're going to come back to you, okay? Stand by though, don't go anywhere. A few minutes, okay? Mr. Gladney, I apologize.
Not a problem.
Go ahead.
House Bill 139 calls for amendment to Chapter 60, Subchapter K of the Texas Administrative Code, which addresses licensing provisions for our military service members, veterans, and military spouses. These rule amendments implement the legislation by first updating definitions in Chapter 55, Occupations Code, and cleaning up rule language by removing obsolete references to past bills that are no longer needed in the subchapter. And then two, provide for a procedure by which a non-resident military spouse can obtain licensure for a regulated occupation that requires in-state residency. And for TDLR, we have one program that requires in-state residency, and that's property tax professionals. The rules were published in the Texas Register on January 28th. The comment period ended on February 28th. And there was one comment submitted in support of the rule proposal, and no changes were made to these rules as a result of the comment. There's no advisory board associated with Chapter 60 rules, and the department recommends that the commission adopt the rule package as published in the Register with an effective date of May 1st, 2022.
Okay. Any questions for Mr. Gladney? I'll take a motion.
So moves, Chairman.
Second. All in favor, say aye.
Aye.
Opposed? Okay, motion carries. Mr. Gladney, I apologize, I'm asking you to yo-yo back for
Not a problem.
if you don't mind. Okay, Mr. Thielen, musical chairs. You got this. Mr. Bruce, can you hear me? Man, I was just right there. I was just right there. Mr. Bruce, Mr. Hermes, can you hear me?
Unmute.
Mr. Bruce, Mr. Hermes?
Yes, I can hear you.
All right, Mr. Hermes, hang on a second. Mr. Bruce, can you hear me? You're on mute, Mr. Bruce.
I'm good to go.
Okay, all right, gentlemen, I'm gonna read something to you, and then we're gonna go from there and make sure we're all on the same page, okay? We'll hear from the prosecutor first, Mr. Thielen, and then from you. You'll have an opportunity to speak. Make sure you speak clearly, say your name and who you represent. Each side will have 5 minutes to speak. We'll keep time, and then maybe we'll allow a 3-minute rebuttal. Please understand the commission can only hear information that was in the record at the SOA hearing. You must limit your comments to these matters so that we're present at the SOA hearing. Do y'all understand, gentlemen?
Yes.
Excellent. All right. Mr. Thielen.
Good morning, Commissioners. My name is Trevor Thielen. I'm a prosecutor with the Enforcement Division who worked on this case. We recommend you reject the Administrative Law Judge's PFD and deny Christopher G. Hermes' Incident Management Tow Operator License application. The department first issued the applicant a tow operator license in 2008. In 2009, the applicant pled guilty to driving while intoxicated and received a year-long probation sentence. The department renewed his license later that year, likely because this was the first offense, possibly because the offense had occurred in 2006, which was 3 years earlier at that point. The applicant remained licensed as a tow operator, renewing his license regularly until 2015. In 2015, the department proposed to revoke his license after he received 2 additional DWI convictions, one in 2014 and the other in 2015. Unlike in his first DWI, where he got probation, the sentences for his second and third DWIs were jail sentences, one for a year, the other for 6 months. The applicant agreed to surrender his license in 2016 and accepted revocation. Then in December of 2017, the applicant committed his 4th DWI. He pled guilty to this felony offense in January 2018 in exchange for a 2-year prison sentence. He was released from prison to parole in November 2018, and he was released from parole in January 2020. 7 months later, in August 2020, he filed the Incident Management Tow Operator License application that you are considering today. Enforcement recommends you deny this application for 2 reasons. 1, because of the 4 DWI offenses and the concerns they raise about him operating a tow truck so soon after completing his latest sentence. And 2, because the only significant evidence presented at the hearing about his rehabilitation came from the applicant's own uncorroborated testimony. The concerns about a tow operator having 1 or 2 DWIs, let alone 4, are obvious. A tow truck is a heavy, unwieldy vehicle that is used to transport other vehicles, and sometimes people. Add alcohol or other intoxicants into that mix, and property damage is the best case scenario. Injury or death are the worst. We don't have to speculate whether the applicant might cause damage or act irrationally while driving drunk. During his second DWI, he crashed his vehicle into multiple other vehicles as well as into a house, and then he fled the scene in his vehicle. As far as rehabilitation evidence goes, the applicant testified that his parole from November of 2018 until January of 2020 required him to attend AA and complete an alcohol awareness program. He also told the court he continues to attend AA voluntarily. However, he did not provide any documentary evidence of these requirements or of his attendance. No instructions from his parole officer or any letter confirming he completed those requirements. No AA chips, no certificate of completion for the class, no letters of recommendation, no testimony or even a note from a mentor or sponsor. He presented testimony from a retired DPS trooper about his previous towing record, but that trooper admitted his only interactions with the applicant were during those tows. He had zero personal interactions with the applicant, and he wasn't even aware of the three of the 4 DWIs until I told him about them. The applicant also presented testimony from his current employer, who wants the applicant to tow for him. To the applicant's credit, his employer tests him for drugs and alcohol monthly, and he trusts the applicant. But the commission should also bear in mind that this same employer admitted he stood by and continued to employ the applicant as a tow operator after his second DWI conviction in 2014 and after his third DWI conviction in 2015, right up until his license was finally revoked in 2016. The ALJ recommends you do something neither party suggested. Issue the applicant a provisional license. This commission, as far as I'm aware, has never issued a provisional license, and we don't recommend that you start with this case. We recommend you choose solely between issuing a standard license or denying that license. The applicant admitted that his first DWI probation included more significant restrictions than his parole did, plus the threat of months in jail if he screwed up. That experience didn't stop him from committing his second DWI. Realizing he crashed his car into multiple vehicles and into a house didn't stop his third DWI. Sentences of 6 months and a year in jail time didn't stop him from committing his fourth DWI. Given that we are now only 2 years out from the end of his parole term, enforcement does not believe you should determine the applicant is rehabilitated enough yet to trust him with a tow operator license at this point, especially on such meager evidence of said rehab. We recommend you deny this license application, let him continue working for his employer, who said he will continue to have a job even if he doesn't have a tow license, and wait for him to come back and apply after more time has passed and with more solid, corroborated evidence of his rehabilitation efforts. Are there any questions I can answer?
Thank you, Mr. Steele. Any questions?
Not that it matters, but are any of these accidents when he was actually towing?
No, and I want to be clear that the only DWI we're aware of that involved him hitting anything was that second one from the conviction from 2014. I believe it occurred in 2013. The other, the first and the third, we didn't have much detail on the circumstances.
He hit a house, the third, didn't he?
I'm sorry?
He hit a house, and the third? Yeah.
He hit vehicles and a house in the course of the second one. The third one I don't have as much detail about. The fourth one was leaving a bar at about 11:30 at night. They pulled him over for speeding and standard DWI investigation from there.
All right. Any other questions? All right, Mr. Bruce or Mr. Hermes, you're on the floor. Go ahead.
Yeah. Yes, everyone. Pleasure to be here. Sorry for the delay on that. Of course, you called me and the court I'm in called me at the exact same time. So it was a little, trying to do 2 computer screens. But anyway, I believe that I understand that the commission hasn't issued a provisional license, but what would be wrong with that? I mean, certainly we have people who've had some prior problems, giving them some provisions and in order so they can, be granted a license. I don't see anything wrong with that, and I actually think that is probably the way to go in some of these instances, and not just an all or one deal. Either you get it or you don't. my client, I'm not going to try to lessen the prior DWIs. It's actually been 2.5 years now since he got out of jail. He paid a heavy price. He went to jail. I don't know how much more heavier price you can pay for that. But as we sit here today, he's gone through AA. He's, we're I think 7 months from the original hearing date, and I know it's not on the record, but there's been no other instances. His employer is willing to come, put him back in a tow truck and bear that responsibility and possible liability. While the DPS officer, retired DPS officer, did testify he wasn't aware of the prior DWIs. I think the prosecutor asked if that changed his opinion at all, and his response was no, that he thinks that Chris should be back in the tow truck. I'm not going to try to lessen again, as I said at the beginning, I'm not going to try to lessen what happened before. But this is a young man who's got his life back on track, is doing what he's supposed to be doing, and just wants to provide some extra money for his family. And being a tow truck driver, he's a manager at the business that he works at. He's and he's doing what he's supposed to be doing. He's engaged. He has children. He's providing for his family. He just wants to provide a little bit more money, and so that's why we've gone through this process. He's willing to accept provisions. His employer is already drug and alcohol testing him monthly, for obvious reasons. But we sit here today, and he needs to restart his life again, and that's why we would say we should accept the proposal for decision.
Is that it, Mr. Bruce?
That's it.
Okay. All right, commissioners, questions for Mr. Bruce, Mr. Hermes, or Mr. Thielen?
I just have a question on, as far as documentation on completed programs and even drug tests. I mean, is there a reason we didn't have any copies of anything showing that actually had been performed or completed?
It just wasn't issued entered at the time of the hearing, Commissioner. But I mean, there has been no other instances since this. I mean, we're going on 7 months since the original hearing back in September, and his employer, he sits by him today, and he's continued to be employed and has had no problems.
I have a question. So he is employed right now. It's what would be the difference for him to keep this job versus towing if he's already employed?
It would give him a means to make some extra money. And I think he does, just to add to his we all want to make some more money, and it would just give him a means to basically supplement his salary some. He works
Usually managers would probably be a salary, and so if this isn't granted, wouldn't it be to where at least he's holding a job making money?
Yes, I mean he's holding a job making money, but it would give him an ability to make a little bit extra money. He doesn't. The companies needs to have some more incident tow truck drivers, and this would give him the ability to supplement his income. And as his employer stated, look, he's out there if he's going to be out there in my truck, I need to trust him because that liability is going to fall back on me. And that's why his employer has known him for quite a while. And that's why his employer says, yeah, I'm probably watching him more, and this was in testimony in there, than anybody else.
Any other comments?
Mr. Hermes, do you have any sobriety chips for 6 months, a year, 2 years? Number one, my first question. Now, I'm Commissioner Callis. Number two, do you do these randomized tests, or are they just monthly tests where you definitely know about them when they're going to come?
If I could interject real quick, I think the first question about does he have evidence, that's not something that was testified about one way or the other at the hearing, and I don't think it'd be appropriate for him to answer that. I do think he gave some testimony as to the second question about the nature of the testing from his employer. So he could answer that question, I think.
Okay. Mr. Herman?
Yes, it's a random test that he tests me. thumbs up and tells me, hey, go get in the cup, so he can see what, make sure that I'm not doing anything wrong.
Any other questions?
I think you said we've never issued a provisional license for a tow. Is that what I heard you say?
That's correct. From what I could find, looking back over the last 10 years, there's been at least four cases, and this is out of a lot of cases that have come to you from SOA, where the judge has recommended a provisional license be issued. That section that talks about that comes from the Occupations Code, section 530211, right below, it's right below the section that talks about your general power to revoke, deny, etc. The statute is a little confusing because first it says there's some circumstances where you have to issue a provisional license, like if we were trying to deny the license, not based off of the criminal history stuff that Jessica and I are always bringing to you in these types of cases. Then it has a follow-up section that says you may issue a provisional license, but it also restricts you in terms of what reasons a restricted license could be revoked. One of those wouldn't even apply to this case. It says you can have the license be revoked if he violates his probation or parole. Well, Mr. Hermes isn't on probation or parole right now. The only other reasons you can revoke a provisional license are if a new offense is committed or a rule or law of the program is broken. It doesn't, from my reading, look like you can put additional conditions on there, similar to the restricted licenses that you may be familiar with. That restricted license is only available in AC, air conditioning and electrical cases, not in tow cases. The length of a provisional license is also a concern. It's limited to 6 months, at which point it has to graduate to becoming a full license. Now, we didn't have testimony about provisional licenses, and I'm getting a little afield of the reasons, technological or logistical, why it may not be feasible. Maybe GC can help out on that front, but I felt it significant that every time this has been suggested, including by the same ALJ, Judge Starnes, the commission in the past and the makeup changes over the years, so the commission has always declined to issue a provisional license. This is a statute that applies not just to TDLR, but to many, many agencies. And maybe it works better at other agencies. I simply think it's better to make a clean decision of a full license if you trust him enough, or no license if you don't trust him enough. Because of the short window of supervision, the limitations on TDLR's ability to monitor these things, the limitations on putting, additional restrictions on him that could be violated or explored.
So Mr. Thielen,
and lack of evidence.
The commissioners are fully aware of the provisional restricted difference, I think. But to your point, I think it's important to state that. But you're fully aware of the restrictions, okay, on provisional versus a restricted license. Okay. Mr. Bowman, do you want to say something?
If there are any questions, I think Mr. Dillon did a good job of outlining it, and he's correct that we have never issued a provisional license. Specifically, we've done the restricted license in those cases where it's authorized. You probably do have, I think, legal authority to issue a provisional license, but for the reasons I think Mr. Thielen outlined, we've just never done that.
Right. And if I might respond, certainly another DWI offense or something like that would violate the code and would be if that was provision, it would it's only a 6-month license, and drug and alcohol testing is in the code, or drug testing is in the code, so that there is those provisions are, and that's what we're here about. If he violated those provisions, he would lose that restricted license.
Functionally,
provisional license.
Functionally, I think the mechanism to execute revoking the provisional license or the normal license would be the same. We would bring a case So I guess my argument against that would be, we're already doing criminal history checks. We're going to find out if he gets a DWI again. We're going to bring that case again if the facts demand it. And here it seems like they would. And it's not going to be an instant thing. You've seen in this case how long it's drug on. The application was in August of 2020. The hearing was 7 months ago. And now we're finally getting to the commission stage. I wouldn't expect too much of a better, assuming there's not an additional pandemic in the meantime, maybe that time would be shorter the next time, but these cases, they take time. And the statutes let you keep the license that you have until we finish our case.
Right.
And it just seems like it's a difference without a distinction.
The code does give you some emergency enforcement authority too, to revoke the license, to suspend or revoke the license in a much shorter time period.
Okay. All right, we're broaching way outside, and I want to be careful about that. So, any other comments, commissioners? At all? Okay. I'll take a motion. Commissioners, or any other comments? Mr. Hermes, while they're contemplating, let me tell you a little bit, and I want to be clear with you, right? I understand, and I was the heart of a lot of this provisional license idea. For me personally, and I don't get involved typically in the nuances of this, I would tell you that time is of the essence. Trust is easily lost and very hard to get back, right? And with 4 instances, I'm not inclined to give that trust back quickly, if you can understand that, right? If I need to err, I err on the side of caution. So I want you to be aware, I appreciate you being here, appreciate what you're saying and what you're doing. I appreciate Mr. Bruce's comments, and that says a lot about your passion and concern for this license, because a lot of people don't even show up. But I just want you to be aware of that trust is slowly earned and quickly lost in a lot of respects. Does that make sense to you, Mr. Hermes?
Yes, sir.
Okay, all right. So any other comments, commissioners, any motions at all?
It's Dr. Callis or Commissioner Callis. First of all, I want to thank Mr. Bruce for being here, and I want to thank Mr. Hermes. The concern that I have is the time is of the essence. We're not talking about 1 DWI. We're not talking about 2. We're not talking about 3. We're talking about 4 DWIs. I will tell you that I'm very proud of you, having friends personally that have gone through rehab and that is fighting such a severe addiction. I agree with what Chairman said. I think that you really only been out of it for not even quite 2 years, and I'm very concerned about the length of time between now and reinstating a license. So first of all, though, and the final comment I make to you, Mr. Hermes, I know you're turning your life around because it's all about you having your own accountability. I deal with addiction not only on narcotics but also with alcohol, and I appreciate you being here today, and I want to definitely tell you congratulations on being sober.
Yes, sir.
Is there a motion?
I'll make a motion that we modify the PFD to deny the license at this point.
Okay, is there a second? Yes.
Second.
If, Mr. Chairman, if I could maybe chime in with some of the particulars.
You need to get the findings changed, right? Go ahead and chime in with those, please.
I think well, first of all, you would be modifying the PFD, and you can disagree with the ALJ if you believe the ALJ did not apply the law correctly here, and you would be looking at conclusions of law 13, 14, 15, and 16.
Okay. So your provision is to deny the license, right?
Yeah.
In findings of 13, 14, 15, 16. Right. Okay. Is that okay with you, Mr. Bowman? Are you still good with your second, Mr. Dr. House?
Yes, the modification of the PFD with 13, 14, 15. I'm fine. I'm reading it right now. Yes.
Okay. All right. All those in favor say aye.
Aye.
Aye. Opposed? All right, motion carries. Mr. Hermes, you have other routes, and I'm sure Mr. Bruce will go through that with you, but I want you to know two things, and I want you to be clear with you, right? As we go through these cases, I'm sure each commissioner could probably give their 2 cents, but I want you to be aware that time is the healer in this provision. And so as you go through that, I think that as commissioners look at this, that's gonna be your biggest friend, consistency in time. So be aware, and if you have any questions, I'm sure Mr. Bruce or one of our staff will be able to help you, okay?
All right, yes.
All right, thank you, Mr. Bruce.
Okay, just a quick question off subject. Are we going to continue to do the contested cases via video? Is that gonna be something in the future?
Mr. Bruce, I've never loved you more than I love you right now, because I am going to bring that up at the tail end of this meeting, so I'm going to give you a cliffhanger. Stay tuned, sir, okay?
I appreciate it,
And I will make sure our staff, if you can, I know you've got other cases, if not, I will make sure that you're fully aware of what changes we have in front of us, okay?
Thank you so much. Appreciate it.
Thank you, Mr. Bruce.
Okay, bye-bye.
Thank you, Mr. Hermes.
Thank you.
All right. Mark, we're back. Yes, we are. All right, from outer space. All right, that's a good song, by the way. All right, no humor today. Item L, Mr. Gladney.
Good morning, Mr. Chairman and Commissioners. My name is Mark Gladney, Assistant General Counsel for TDLR, and I'm here to present for adoption by the Commission the next rule package implementing House Bills 3312 and 3319 and Senate Bill 1831 passed in the last legislative session, which pertained to driver education and traffic safety program. This bill calls for amendments to Chapter 84 of the Texas Administrative Code, which addresses curriculum changes in Subchapter M of Chapter 84, requiring inclusion of instruction in driver training courses on the following topics: human trafficking, the dangers and consequences of street racing, and procedures and restrictions related to the passing of certain emergency vehicles on public roadways. This rule package also implements the bills by updating the driver training curriculum in the DES program guides that were adopted by reference in Chapter 84. These rules were published by the Texas Register on February 4th. The comment period ended on March 7th. There were no comments received during that period. Now, the Driver Training and Traffic Safety Committee met on March 15th to discuss the rules and recommends adopting the rule package and the program guides as published in the Register, and with 2 changes. Both of them are in the Program of Instruction Driver Education Program Guide. The first change is at Module 11, Classroom Instruction Minimum Timeframes Chart at Section 11.1.4, Anatomical Gifts, by correcting the lesson number from number 20 to 29. And the second change is correcting the minutes remaining for allocation for other topics applicable to Module 11, and we changed that from 15 minutes excess to 25 minutes after advisory board discussion. Thus, the sentence immediately at the bottom of the chart that's in your briefing papers, the sentence immediately below that chart has been changed to read, the remaining 25 minutes of instruction shall be allocated to the topics included in this module that satisfy the educational objectives of the course. It used to say 15 minutes, now it says 25. These changes are non-substantive, and the department recommends that the commission adopt the rule package and program guides as published and with the recommended changes from the DES Advisory Committee with an effective date of March 1st, 2022, in accordance with the adoption deadline for the 3 bills implemented in this package. That's it.
Any questions for Mr. Gladney?
And Mark, I'm sorry to interject, Brad Bowman, good presentation. I think May 1st would be the effective date.
So May 1st.
Correct.
Did I say something on May 1st?
I think it was March, but so May 1.
That's the second time I've done that. But May 1st, 2022.
All right, we got May 1st. Thank you, Mr. Gladney. Any questions? All right, Commissioner, entertain a motion.
A motion to approve the changes for the driver education and safety program.
Second?
A second.
All in favor, say aye.
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 Opposed? All right, Mr. Gladney, item M.
Thank you. For the record, Mark Gladney, Assistant General Counsel, TDLR, and I'm here to present for adoption by the Commission my last rule package implementing Senate Bill 916 that was passed in the last legislative session, which pertains to the Property Tax Professionals Program. This bill calls for amendment to Chapter 94 of the Texas Administrative Code, which has the Commission to adopt a rule which requires the Department to provide an electronic link on its website that connects a user to the findings from the Comptroller's biennial review of an appraisal district during a time that the selected registered professional appraiser was serving as chief appraiser for that district, as well as including the property value study used by the Comptroller in each review. So this electronic link allows the public to easily obtain data to evaluate the performance of a chief appraiser for an appraisal district during a specific time of his or her tenure. The rules were published by the Texas Register on December 10th, 2021. Comment period ended January 10th, 2022. There was one comment received during that period. No changes were made as a result of that comment. The proposed rule was not brought before the Property Tax Professionals Advisory Committee as it was strict bill implementation. However, the presiding member was consulted and advised and approved of the proposed rule. No comments in opposition were received, and the department recommends that the commission adopt the the rule package as published with an effective date of May 1st, 2022.
Good date. Any questions, Mr. Gladney? By the way, it's a great change, I mean, to be able to get that link.
Oh,
that's,
it's been working for several months, and we've gotten some positive feedback on that link.
Good job. Good job. Any comments? Well, entertain a motion.
Make a motion that we adopt it.
There's a second?
Second.
All in favor, say aye.
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 Opposed? All right, Mr. Gladney, thank you.
Thank you.
Mr. Phipps, how are you, sir?
Doing well, I think.
Item N. I'm looking down here, so I don't know how that works. Stay by. And our numbers. Go ahead, Mr. Phipps.
Good morning, Commission members. I'm Alex Phipps, Assistant General Counsel, here to present Agenda Item N, and this is a package of rules for Chapter 114 of the Texas Administrative Code. These are the orthotics and prosthetics program rules. The package that we have for you today here under Agenda Item N is a comprehensive review of the chapter. This was conducted by TDLR staff as a part of our rule review process that's required by the Texas Government Code. Once we conducted the normal rule review process required by the Government Code, we conducted multi-division meetings to identify issues that are in this chapter that need to be addressed. So this is a comprehensive chapter-wide evaluation conducted by staff. I'm going to talk about the general concepts that we implemented through this rule package instead of going specifically section by section, because it does touch on almost all of the sections of this chapter. The changes identified by the staff in this package remove outdated language related to the administration of examinations by the department. So the department no longer administers the examinations directly. We do have a contractor who does that for us, but the language does imply that the agency is still administering the examination, so we're removing that language. We're making clarifying changes about the application requirements for a license. We're correcting erroneous text about the proper scope for assistant licensees. We're simplifying the submission requirements for facilities and removing the fees for changing a practitioner in charge or a safety manager. We're clarifying which categories of continuing education may be taken remotely for credit, and we're cleaning up the rule that covers continuing education generally. We're eliminating the fee for the voluntary charity care status, and we're amending the scope of practice rule to indicate that telehealth is acceptable within the licensee's scope of practice and in accordance with the existing off-site practice requirements, which are already in the rule. So the advisory board for OPS first took a look at this on October 21st of last year. They recommended several changes, which staff incorporated. The package was proposed in the register on November 5th of 2021. We received no comments during the proposal. The second advisory board meeting on February 28th, 2022 was held, and the advisory board had no changes to the text. They voted to recommend adoption of the package as proposed in the register. So staff brings this to you today. We request an effective date of May 1st, 2022, and I'm happy to answer any questions you may have.
Any questions? All right, understand motion?
Make a motion, we accept.
So moved.
Second?
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries.
Tell the advisory thank you for that. Absolutely.
Go ahead, item O.
Morning, Commission members. Alex Phipps again. I'm here to present agenda item O. So this is a revision of Chapter 100 of the agency's rules in the Texas Administrative Code. Chapter 100 is the general provisions for health-related programs. These rules are generally applicable to certain health programs that the agency regulates under Title III of the Occupations Code. The changes that we have for you today are a combination of changes from the rule review process, very similar to the package we just discussed, as well as bill implementation for Senate Bill 40 from the 87th Legislative Regular Session. So we've combined those two sets of changes together into this one rule package. Again, this is a pretty comprehensive change. We're reorganizing Chapter 100 into subchapters. We are separating existing provisions related to the administration of certain health-related programs, and then we are adding regulatory provisions about telehealth and remote continuing education. We're also removing podiatry-specific provisions and moving those to Chapter 130, which will be the next agenda item that we have on the agenda today. I'll go subchapter by subchapter because, again, we are making significant changes to the structure of this chapter. Subchapter A is the general provisions that will reflect the applicability of the entire Chapter 100, establish definitions, and grant enforcement authority for violations of the chapter. Subchapter B will be the certain health-related advisory boards provisions. So these are required provisions to implement Texas Occupations Code 51.2031. So that's an existing provision that covers athletic trainers, behavioral analysts, dietitians, hearing instrument fitters and dispensers, midwives, orthotics and prosthetics, and speech-language pathology and audiology. So those are existing rules we currently have in Chapter 100. We're now moving those into Subchapter B. We have to maintain those since they are required by statute. We're also cleaning up this area in Subchapter B by removing the podiatry-specific provisions and moving those to the podiatry-specific chapter. So they're being repealed in this rulemaking. The next subchapter is Subchapter C. This is a new subchapter, and this is new text. This will be implementing the telehealth provisions of SB 40. This subchapter applies to all health programs regulated by the department under Title III of the Occupations Code. So that will add to the list I just read to you, podiatry, licensed dyslexia therapists, and massage therapists. This will implement the new Texas Occupations Code 51.501. The title of that section is telehealth. That gives the Commission authority to adopt rules related to telehealth for health professionals. Health professionals are any persons holding a license issued by the department under Title III of the Occupations Code. Subchapter in addition to all the other applicable laws and rules that apply to these professionals. And if a provision of this subchapter conflicts with a law or rule governing a program, the program-specific provision will control. And that's an important point to keep in mind because this is an overarching provision that applies to all of these. If there's a more specific provision in any of these professionals' licensure laws or rules, that will be the controlling provision that's important. And we'll revisit that here in a minute. The subchapter establishes broad guidelines, including standard of care applicable to telehealth services. The applicable standard of care will not be higher than the in-person service of that same type. We will establish guidelines for appropriate patient care and fraud prevention, including communication with the client, proper consent, client identification, and documentation of services that are being provided. We will also be establishing a requirement for responsibility of health professionals to protect patient privacy as required by federal and state laws that apply to that professional. And that responsibility will extend to all persons under the direct supervision or guidance of that health professional operating under their license. And finally,
how many licenses fall under this provision?
I don't have that number for you, but it is 10 different sections. I can list the actual license types, but we can absolutely pull that up for you.
So would that change the list that you presented to us?
No.
Continue on if there's no.
Yes, sir, you're good.
Sure. Subchapter D is the last subchapter that we're adding to Chapter 100. This is the remote continuing education provision. This has the same scope of applicability, all Title III licenses issued by the department. It also has the same deference to program-specific laws and rules that we talked about in the previous subchapter. This is also implementing Texas Occupation Code 51.501. And so the provisions of this subchapter permit, a health professional to complete continuing education requirements through remote continuing education if it is permissible under the applicable federal and state laws and the rules governing that professional's licensure. It also provides for disciplinary action if that person utilizes remote continuing education in an attempt to avoid licensure requirements. So the advisory board does not exist for Chapter 100. We did not take this to an advisory board, but we did inform the presiding officers for all of the affected advisory boards under the 10 different license types that are under Chapter 100. We also distributed information about this rulemaking to all email lists for those license types. We received 6 comments after the publication of these rules. They were published on January 28th, 2022. I'll briefly address those comments. No changes are being recommended by staff as a result of any of these 6 comments. The first comment we received was from the Texas Academy of Nutrition and Dietetics. They submitted a comment in support of the proposed rules. The department appreciates that comment and made no changes. Then we received 4 comments, one from the Texas Podiatric Medical Association and 3 doctors of podiatric medicine. They were requesting an interpretation change to the applicability of continuing education. This was in Chapter 130, there is a rule that touches on continuing education. Unfortunately, that rule is not a part of this rule package and is not being opened up in any of the rulemakings that are in front of you today. So to the extent that this is requesting an amendment to an existing rule that is not in this package, it's outside the scope of this rulemaking. Staff's not recommending any changes as a result of that. And finally, we have a comment from the Texas Hearing Aid Association, and they are generally in support, but they did recommend 2 text changes to section 100.1 and 100.72. Staff reviewed their recommended text changes. We feel that the changes would introduce more confusion and possibly introduce some confusion about the scope of applicability. So we declined to implement their recommended changes, but we did appreciate them providing that suggestion. So those are the 6 comments that we received. As I mentioned, staff requests adoption as published in the register, and we recommend a effective date of May 1st. Happy to answer any questions you may have.
Any questions?
Yes, I have a question for Mr. Phipps. Mr. Phipps, thank you for you and TDLR bringing healthcare related programs to the 21st century related to telehealth and telemedicine. The only question I have is the same thing I had whenever we were presenting this at the for Texas Medicine and Texas Medical Board. Is there going to be a hotline, or there's going to be avenues to where the patients or the Texans that are being taken care of by these health related programs to make sure that we have a quick response for waste, fraud, and abuse?
I don't have any specific information about whether we will have a hotline dedicated to telehealth or to accept telehealth-related complaints. I believe that the Enforcement Division is already accepting complaints related to the practice of our licensees. I think this would easily fall under that. But of course, staff can work along with members of the community or anyone who wants to offer any suggestions about how we would better incorporate that.
I was just asked. I appreciate your comments, sir.
Sure.
Any other questions? It's comprehensive.
Very comprehensive.
So 10 licenses.
10 different license types, 10 different programs. There are actually several different license types under those programs.
But overall, I'll entertain a motion.
Make a motion to approve the telemedicine/telehealth general provisions for all health-related programs.
Is there a second?
I'll second.
All those in favor say aye.
Aye.
Opposed?
Aye.
Thank you.
Motion carries. Thank you. All right, item P.
Morning, Commission members. Alex Phipps again. I am here to present the Chapter 130 Podiatry rule changes that we have for you today. As I mentioned in the previous package, we had to move several podiatry-specific provisions out of Chapter 100 as our reorganization of that chapter that we just discussed. These provisions are required under Texas Occupations Code 51.2032. So we have to move them somewhere else in our rules. And the appropriate place to put those is Chapter 130, which is podiatry specific. So we are amending one existing rule with this rule package. That's 130.27. We are incorporating the requirements under 51.2032 to that section. So it's a pretty large expansion of the text of that section, but this text is not new. It's existing text that we are simply cutting and pasting basically over into Chapter 130. The other thing that we're doing is we're adding a new rule 130.75, and this is an enforcement provision section. This section also is modeled on existing language in Chapter 100. So again, we are not creating new concepts or new applicability here. We are simply just moving it over from 100 to 130. This was not taken to the advisory board because it is a simple relocation, but we did inform the chair of the advisory board, and we did distribute notice of this to the email list for podiatry. Published in the Register on January 28th of 2022. We did not receive any comments, so staff recommends adoption as published on with an effective date of May 1st, 2022. Excuse me.
Okay. Any comments, questions?
I'll make a motion to accept, effective May 1st.
Is there a second?
I'll second.
Second.
All in favor, say aye.
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 Opposed? All right, motion carries. Thank you, Ms. Phipps, appreciate it. All right, item Q, Ms. Mary, where are we? Ms. Mary.
She may be joining online.
Good morning.
There you are, Ms. Mary. How are you this morning?
I'm good. I'm good. Good morning, Mary Winston, TDLR, Advisory Board Attorney. This morning, I will be presenting the recommendations for appointments for advisory boards. And thank you for running the slideshow, Christine. Our first appointment recommendation, we have Kyle Stell of Houston, Texas, for the Board of Boiler Rules. For Code Enforcement Officers Advisory Committee, we have Kenneth Rocha of Austin. For Dyslexia Therapists and Practitioners Advisory Committee, Hector Garcia of Abilene. For the Electrical Safety and Licensing Advisory Board, Kim Allen of Rockwall. Elevator Advisory Board, Brian P. Mitchell. Licensed Breeders Advisory Committee, Christina Stevens of Crowell. Also for licensed breeders, we have Kirby Gange of Louisville and Valerie Devaney of Sugarland. For Orthotists and Prosthetists Advisory Board, we have Eric Olson from Round Rock. Registered Sanitarian Advisory Committee, Terry Lynn Barber of Plano. Speech Language Pathologists and Audiologists Advisory Board, Sharice N. Andrews of Houston. For the Texas Water Well Drillers Advisory Council, we have Mr. John Mike Pyburn of Manville. Also for the Water Well Drillers Advisory Council, Michael Becker of Marble Falls, Texas, as well as Roger Russell of Nacogdoches. Now we have reappointments, those of already existing who've accepted the call to continue. For Code Enforcement Officers Advisory Committee, we have Jody Nake of Fort Worth. For Dietitians Advisory Board, we have Mary Kate Susie Weems of Waco. Elevator Advisory Board, Mr. John T. McGraw of Austin. Also, Jerry Matheny of San Antonio. And Sheila Sweat of Houston, Texas. Lastly, we have presiding officer appointments. We thank them for taking this additional service. First on deck, we have for Air Conditioning and Refrigeration Contractors Advisory Board, Mr. Jerry Bittner. For the thank you. For the Elevator Advisory Board, Grayson Gill Jr. of Dallas. For Registered Sanitarian Advisory Committee, Stephen Katsatos. Texas Water Well Drillers Advisory Council, Johnny L. Rusty Gilmore of Dalhart. Presiding Officer reappointments, just a few of those. Architectural Barriers Advisory Committee, John Ricard of Austin, Texas. The Auctioneer Advisory Board, Mr. Rick Stroud of Bernie. Behavior Analyst Advisory Board, Dr. William Gordon Borland of Arlington. Code Enforcement Officers Advisory Committee, Ms. Teresa Adrian of Irving, Texas. Combative Sports Advisory Board, Dr. Wayne Lee of San Antonio. Electrical Safety and Licensing Advisory Board, Joseph Mark Roach of Portland. Hearing Instrument Fitters and Dispensers Advisory Board, Mr. Lance Brooks of Paris, Texas. Massage Therapy Advisory Board, David Lauderstein of Austin, Texas. Midwives Advisory Board, Ms. Laurie Fremgen of Austin, Texas. Motorcycle Safety Advisory Board, we have Mr. Keith Ravel of Houston. Property Tax Consultants Advisory Council, Stephen G. Mills of Dallas. Speech Language Pathologist and Audiologist Advisory Board, Ms. Sherry Sensibrian of Lubbock. Towing and Storage Advisory Board, Amy Milstead of Spring. And finally, for the Weather Modification Advisory Committee, we have Frank Riley of Horseshoe Bay. This wraps up our list for your consideration. Thank you.
Mary, thank you so much. I know this is great. Commissioners, let me be clear here. This is probably, if not the one critical thing we need to focus on. If you have people that you can put on these advisory boards, let them, Mary, know. She is always seeking for qualified people. And as we become more responsible for a diverse group of licenses, we cannot know everything in these locations. So these are our hands and feet. So anything you can do to help her or nominations, please let me know. Mary, you do a great job. Please communicate to the advisory board. We realize that they're working hard for us and we appreciate what they're doing.
How are these meetings?
Thank you, sir.
Done?
Most of them are virtually, correct, Mary? They still
Most are now virtually. Currently, all are virtually.
So, and
And if you need somebody to fill certain ones, let us know and we'll see if we can find somebody to help you.
well, let me jump in. We need somebody
Yes.
always in every one of them.
Okay.
So if you
What's
got
your
it,
capacity? Yeah.
you throw us the names,
Okay.
we'll take a look at it.
Oh, okay.
For sure. Also, if you get a chance to pop in, and I've done that periodically, these advisory boards, to let them know that we're here, we're listening to them. It's not a vacuum that they're working in. It's always great. Always great. And great, especially Dr. Callis, Dr. Weston, the medical expertise you bring to it, that we just spoke about, these 10 licenses. I mean, it's always great to have your expertise in that. So anytime you can jump in, it'd be great. You don't have to be assigned to the advisory board to not jump in, okay? Do I need a motion for this, Brad?
Yes, sir.
Okay, I need a motion to approve these advisory board appointments.
Make a motion to approve the appointments and reappointments of members of the advisory boards, including appointments of presiding officers.
Second.
All right, all those in favor, say aye.
Aye.
Opposed?
Aye.
All right, motion carries. Thank you, Mary. Thank you for your work. We appreciate you.
Thank you, Chairman. Thank you, Commissioners.
Okay. All right, staff reports. Mr. Mike, item R.
Mr. Chairman, Commissioners, we have kind of a small staff report that we have for you today. What we're going to try to start doing is placing the staff reports within your packet of information that you have and provide that to you at any point in time. If you have any questions, we would, of course, strongly encourage you to just feel free to ask those questions as you need to. We went through the largest portion of it, which is the strat planning, which is taking up considerable amount of time for the agency at this point in time. But as was mentioned earlier, the subgroup will help us with that and be able to move forward with the strat planning sessions and get that document created and ready to present to the commission on our May 24th meeting. And then at that point in time, it would be probably just some grammatical changes that we need to make. that we'll be requesting approval for, and then we'll be able to submit it in on our June 1st date. So at this point in time, there's really not much more we can do. We're still moving forward and trying to get everything organized. We will have a return to office back to our agency looking at next Monday. So we've had a conversation with our staff, so they're fully aware, so they're ramping up, getting ready to put their plan in place. So you should start seeing, I think today's meeting is kind of an example that we have people starting to come back in. So we have a pretty good house today, so we're looking forward to that. I'm available for any questions that you may have.
Any questions for Mike? So you said full staff, what does that look like?
What we've done is we've kind of charged each division director to look at their particular division to see what their staffing levels need to be in order to make sure, of course, that first of all, is make sure we have safety as a top priority for our employees, but also have them start returning back to the office on a periodic basis throughout the week. And so each division is working on that. We do have some divisions, of course, as example, field inspections that have been out the whole time. We have some staff in our financial services that have never gone home because of the nature of what they do. And so we're just kind of looking at it from each division standpoint, but they will be start rotating in and out of the office. So we'll have kind of a presence here at the North Campus location, also our downtown location, and along with having them be able to work from home also to not have a mad rush back into the offices, but kind of stagger them through.
Okay. Any other questions?
Thank you.
Good. Mr. Bowman, can I bring up the virtual capacity now, or you want me to?
Yes, sir. This is Brad. The items S and T are talking about future commission meetings, so you can talk about logistics and how you want to handle those.
All right. You're taking the leash off. All right, good man. Thank you. All right, so we combined our meetings, which you gotta love. We took 2 to 1. So May 24th is the date. So I want to make sure that that's a critical meeting for many reasons. So if you can't make it, please let us know quickly. Let the staff know if you don't mind. I mean, Carney said, I think you're working on that.
Yes, sir.
Because the specific date, yes, sir, Dr. Callis.
I will not be able to attend. That is my anniversary, and but if you do virtual, if it's in the morning, I might be able to attend. I'm just asking if that's a choice.
You sure you don't want to bring your wife?
My wife's not going there for.
All right, be a heck of an anniversary gift. I'm not gonna lie. All right, well, if you can't make it, let us know. We're gonna try to do it. We're also, I wanted to get your feedback as to how we integrate any more virtual conversations into our meetings. I know the staff's done an exceptional job of working through the logistics of this. My intention is to go without virtual. If you have concerns, issues, let me know. I'd be happy to address them and go from there. That's the intentionality of it. I know that we've kind of gotten into a new rhythm, but I think it's important that we see each other in 3D. So I'm gonna press that as far as the presentations for our board to make sure that if you have a comment or anything like that, I think we would do is we'll make the virtual the exception to the rule, and if somebody can stipulate a reason why they can be or has to be virtual, whether it's they don't feel well or some sort of economic challenge that's beyond their control, then I understand that. We'll take that on case by case. But with that being said, we're going to go physical. I don't know what that means. I guess non-virtual. What's the word I'm looking for here?
In person.
In person. Thank you. In person. So any questions, let me know. Okay.
Mr. Chairman, the only question or concern that I have, the reason why it's always good to have a hybrid, due to the fact that if we didn't have a hybrid today, we wouldn't have had a quorum because one of our members was supposed to be there physically, and then we had to go to a virtual, so we were able still to conduct business. It's my intent to come every single time in person, but if not, I still would like to be involved virtually due to the fact that being a physician and taking 2 days out of the operating room, sometimes it's hard for me to do that.
Understood and noted, Dr. Callis. Thank you so much. I appreciate that.
Thank you.
All right. Anything else? Okay, so the next meeting is the 24th. We'll look at if you can make it or not. Any other items that I missed? Mike, Brad?
I believe we got them all.
Commissioners, any other items you'd like to address that I missed? All right, with that, meeting is adjourned. Gary?
Yeah, I have it.
Nora?